In a significant legal turn, former President Donald Trump has secured what appears to be a substantial victory in the New York Appeals Court, potentially nullifying a civil fraud verdict that initially carried a financial penalty exceeding $400 million. The decision, under intense national scrutiny, could result in Trump recovering as much as $1.05 billion in assets and interest, an outcome with wide-ranging legal and political implications. The case in question stems from a civil action spearheaded by New York Attorney General Letitia James, who accused Trump of grossly inflating the value of his real estate assets to obtain favorable loan terms. The central claim held that Trump's reported financial statements misled banks and insurers. However, during appellate proceedings, skepticism emerged from the bench over both the legal foundation of the case and the evidence presented. Justices on the appellate panel questioned the appropriateness of invoking state fraud statutes in a matter involving experienced corporate parties who, according to court records, suffered no financial harm. Some comparisons were drawn with past cases involving the 2008 mortgage crisis, such as actions against Lehman Brothers or fraudulent appraisers that significantly affected consumers and financial markets. The court noted that such damage was absent here, with both Deutsche Bank and other lenders reportedly profiting from their dealings with Trump. A key moment in the proceedings came when the court directly challenged the Attorney General's legal counsel. When pressed, the state's representative argued that Deutsche Bank had been harmed. The justices, however, appeared unconvinced, especially in light of testimony from Deutsche Bank officials, who stated that they not only approved the loans, but profited handsomely from them. Internal emails further revealed that bank executives had maintained a favorable opinion of Trump and his business operations for years. Trump just won $1.05 billion New York Appeals Court victory, with interest after James' mortgage case. Central to the case is the valuation of Trump's Palm Beach estate, Mar-a-Lago. The state had valued the property at approximately $18 million. However, multiple real estate experts familiar with the Palm Beach market contended that this figure was significantly below market value. According to them, land on Palm Beach Island, where scarcity is a defining characteristic, often sells for upwards of $1,600 per square foot. Sales on the oceanfront have reportedly reached as high as $2,000 per square foot. Mar-a-Lago, spanning 20 acres, was compared to a recent $152 million sale of a private island nearby. By $5 billion, with its 100,000 square foot structure adding potentially another $500 million in value. This dramatic discrepancy in valuation led many to question the state's methodology and whether it reflected a political bias rather than an objective assessment. The appellate court echoed similar concerns, inquiring into how such a case aligns with the original intent behind the state's consumer protection laws. Specifically, the court examined the legislative history of the statute invoked. General Business Law Section 6312, finding it was crafted primarily to address issues of consumer fraud, civil rights violations, and environmental misconduct, rather than disputes between financial institutions and sophisticated borrowers. Legal analysts caution that if civil statutes designed to protect everyday consumers are extended into arenas of high-stakes political litigation, it could deter future investment in major markets like New York and set a precedent for prosecutorial overreach. Adding to this, the reaction from Deutsche Bank representatives during the trial appears to have undermined the foundation of the Attorney General's case. Multiple employees testified that the bank had independently verified Trump's financials and that no reliance was placed solely on his self-reported valuations. They confirmed that all loans were repaid in full, with interest, and that Trump's business dealings had generated millions in revenue for the bank. Their statements, documented in years of internal communications, painted a picture of a beneficial and transparent financial relationship, not one rooted in deception. Several prominent legal scholars have weighed in, noting that the combination of skeptical judicial questioning, contradictory witness testimony, and a statutory framework not originally intended for this type of dispute makes the state's position difficult to sustain on appeal. to sustain on appeal. Should the appellate court formally overturn the lower court's judgment, it would not only restore the disputed funds and interest to Trump, but also reinforce limits on the scope of state civil fraud statutes. As the appeals court prepares its final opinion, observers on both sides recognise that the outcome will reverberate beyond this single case. For Trump, it represents vindication after a high-profile legal battle. For Attorney General James, it will test the boundaries of her authority to pursue civil actions against political figures under New York's consumer protection laws. And for the broader financial community, it will clarify how far state prosecutors may go when challenging transactions among sophisticated, well-represented parties.